A strong sense of families and religious sanctity are two important factors that keep marriages together. Now, this is not something I am saying, this is something Kiran Chadha has said, and we couldn't agree with her more. More so, work from home can be a blessing in disguise if everyone learns to share work and accommodate each other. However, despite our Indian society giving more importance to the rules laid down by the society than on individuality, I do believe there is a gradual shift in the married couples of today choosing happiness and peace of mind over a lifelong journey of stress, misunderstanding, or even worse, collateral damage. With extended support of the near and dear ones, there is absolutely no doubt that a divorce goes through a lot of compromise, making certain adjustments and sacrifices, and in more cases than not, and as I had mentioned in the previous webinar, there are higher chances of men divorcing women, leaving them helpless and in despair. Welcome to My Fun Bazaar Academy and welcome to our initiative, our talk show, Ask the Lawyer. We have a reputed Supreme Court lawyer telling us the nitty-gritties and the legalities of the law under the Indian jurisdiction, like in our previous two episodes, the legal will and the maintenance of provisions under the matrimonial laws. Now, if you've missed seeing those two episodes, I'm still going to leave the cards on your screen. If you've missed that, you could catch these two episodes on our description box below, which you can watch later. With divorces becoming normalized in India and coming to this webinar's topic, we have the expert, Dr. Neela Gokhale, who is going to de-blur the mist of how to go about getting a divorce, every woman's rights in terms of getting her divorce, and the significance of an online application for divorce in India, to name a few. It is always a happy moment for me to be sharing the screen with you, Mrs. Gokhale. Now, before I head into the questions for today, today's topic is grounds for divorce and everything a married couple is supposed to keep in mind while considering a divorce. Without constantly hushing about it, I'm clarifying the prospect of marriage to an extent that the entire process of a legal exit has been vilified. Mrs. Gokhale and I hope to break some stereotypes that lie around an unhappy couple or a compromised arrangement more in our heads than in the heads of our Indian society. Even today, we do not prepare our daughters or would-be brides on how to deal with a marital alliance they aren't happy to be in. But really, times have changed, don't you think? When women no longer are dependent on their near and dear ones, at least when it comes to gaining information in the tech-savvy world that we today live in. So let me start our conversation with Mrs. Gokhale by asking you, what are women's rights after divorce in India? What are your thoughts on the same? Over to you, Mrs. Gokhale.
See, in India, like you said, like the world over actually, when a woman actually decides that enough is enough and I need to move on, and then she really goes for a divorce, the first thing which comes to her mind is after the matrimonial relationship is over and when it is her who has to leave the home, or if she has a house of her own or some economic support if she's working, or if her parents are going to see her through, then the only question remains is that after the divorce, what is she going to do? If she's economically independent, fine, but she also has her children to look after, and if she's going to take custody of the children. And more often than not, it is the woman who has to actually who wants the custody of the children, and who generally is successful in getting the custody of the children. So the most important and pivotal thing she has to worry about is the maintenance for herself and for her children. Now, after her divorce, she's got various provisions, like in the last chat we had, Shruti, in respect of maintenance. I did say that there are a whole lot of, as many as 7 provisions and 7 enactments under which a woman or old parents and children can actually seek maintenance from the husband, or from the son or the father. So, as far as a woman is concerned, the matrimonial rights and obligations arise out of the personal laws of the person who is asking for a divorce. So, if you have married under the Hindu Marriage Act, then you invoke the provisions of the Hindu Marriage Act to seek divorce and maintenance and custody. If you have likewise got married under the provisions of Special Marriage Act, or say the Parsi Marriage and Divorce Act, or the Indian Christian Act, then similarly, simultaneously, your rights and duties arise in respect of maintenance and other family obligations from the provisions of that act. So, as far as Hindu Marriage Act is concerned, for example, or a Special Marriage Act is concerned, if you have already obtained a divorce, the procedure is this basically, Shruti, that when you are asking for a divorce, there are provisions which you can invoke during the matrimonial proceedings, that is during the divorce proceedings. So you must actually ask for maintenance in those proceedings itself, so that you don't have to actually again start further proceedings once the divorce is through. But having said that, for any reason of whatsoever nature, the woman has not asked for maintenance during the divorce proceedings, then she can again go under the same act, for maintenance, and she is entitled to get maintenance. But I pause over here. In case a divorce proceeding is dismissed, okay, so if the woman has contested a divorce proceeding, or if at all she has sought a divorce and the divorce has not been granted for any reason of whatsoever nature, then under the same act she is not entitled to get divorced. The reasoning is simple. If you say, I want to stay with my husband, if a husband has filed a divorce petition against you, and you contest it and say that no, I don't want to give divorce to my husband, I want to live with him, so then the court will not allow you to say that I'm going to stay separate. I'm not going to give divorce to my husband, but at the same time I want to actually seek maintenance remedy from my husband. So in that case, under the same provision of matrimonial obligations, you will not get maintenance under the same in the same proceeding. So what the woman has to do is invoke the other proceedings under other secular laws, for example CRPC, or the provisions under the Protection of Women under Domestic Violence Act, or say the Hindu Adoptions and Maintenance Act, where she is entitled to reside separately without seeking a divorce and still be entitled to maintenance. So there are various provisions under which she can get maintenance. But the point to remember here is this: the decision to break a relationship legally through a statutory legal provision is quite complex. It's quite very difficult, in fact, for a woman to actually come to such a decision. But once having come to that decision, she must actually consult a lawyer and understand what her rights are, and then it becomes easier for her to seek those rights and actually fight for those rights. The rights have been given by the constitution, by the Indian laws. Most of the laws are women centric in our country. The only thing is, the woman must make herself aware of what are her rights, and that is most important, because if you don't know what your right is, you wouldn't know that the right has been violated, right? So that's my answer to the question, to your first question, Shruti, that you are entitled to get maintenance. You just must seek the remedy in an appropriate legal forum, or an appropriate legal court of law having competent jurisdiction.
Okay. So I'm glad you brought up the whole aspect of awareness and how a lawyer needs to be around to kind of ensure that, proceedings happen the right way, which does bring me to my next question. Obviously, you did mention that there are so many aspects and factors to keep in mind during divorce proceedings. So, it is true that lawyers do play a few roles in mediations, whether it's passive or active, depending on the nature and the extremity of the case. So, take me through, I mean, the recommendation as such of, a lawyer being present during these divorce mediations, and what are the advantages it has. Tell me a little more about that.
So Shruti, generally now all the most of the divorces or the matrimonial matters and family matters are do come under the Family Courts Act. Okay, so you don't have to go to the civil courts to seek a divorce or any matrimonial or family remedy. Or not, it's not a family remedy, it's a remedy under the arising out of, say, family disputes. Okay, so every family court, the in 1984 the Family Courts Act has been enacted, and it has come into force also from 1984. So the Family Court Act is a very, very peculiar and a very super specialized jurisdiction given to women and men, and for family disputes. The Family Court Act prescribes that in every matrimonial proceeding or every proceeding under the family law has to be, subjected or has to be sent to a family counselor. Now, every family court is assisted by two family counselors in the family court premises itself. So, whenever a matter comes up for hearing, the first date, okay, the family judge, the judge of the family court, will refer your matter to a family counselor. Okay, now the family counselors are also very well trained in mediation and conciliation proceedings, and they are actually master of social welfare graduates. So they have a sort of a degree in the MSW degrees. Okay, so they're very competent persons. So once the matter is referred to the mediation center or to the counselor, then the counselor will issue notices and call upon both the sides to come and talk to her. She or he will actually talk to the husband, to the wife, to the extended family members, to the immediate family members, to the children. Whoever is may have a influence over the outcome of the proceedings. Whatever the family counselor feels, she or he will call upon those people to come and meet her. There are sessions which happen in the family court, in the mediation center, and thereby the law also makes sure that before the legal proceedings commence, or before the actual evidence act or the civil procedure code actually kicks in, these provisions kick in, the matter is tried to be resolved by referring the couple or referring the parties to the dispute to a mediation center. Now the family counselor will also call the lawyers, to be present. So the lawyer actually accompanying the party can explain to the family counselor the issue, or can assist the family counselor in coming to a particular analysis or a resolution. And many times, a lot of times, the family counselors of a family court are able to resolve the matter. The point is only this: the issue which is before the family counselor is this: either they will come together and resume cohabitation, and perhaps with assistance of the counselor or assistance with the other family members, or if at all the family counselor feels that no, this is this marriage is actually irretrievably broken down, there is no way in which the parties are going to be able to live together properly, then the family counselor will ensure that they part amicably without so much mudslinging, without making allegations on each other, so that there comes a settlement wherein, say, some maintenance, lump sum maintenance or monthly maintenance is to be given by one party to the other. Children are provided for, residences, separate residences are worked out, and then the settlement terms signed by both the parties, by both the lawyers, is presented to the family court. Now, in a situation where both the things are not being able to work out by the family counselor, then the matter is referred back to the court, and then the court will deal with it by following the due process of law. So, mediation and conciliation is a very, very important aspect in matrimonial law, and the Family Courts Act has actually provided for such mediation centers, and the family counselors always are there to assist the family court judge to resolve these matters. So this is very important and very, very facilitating provision in the Family Courts Act, and I think everybody should try this mediation first before jumping into the acrimony. Over to you, Shruti.
Okay, that was a very interesting answer. A lot learned there. If you all think so, viewers, please pause and give us a like. Hit that like button. Okay, moving on. Mrs. Gokhale, I'm just going to give you a scenario here, actually. Okay, let's just name a couple. Let's just call them Jacob and Karen. Right now, they want to end their 10-year-old marriage. Okay, and that on a very cordial note. So, suppose they have the same lawyer, the divorce lawyer, representing them, considering they are opposing parties in a lawsuit, which remains true, obviously, regardless on whether you've agreed amicably to the terms of, divorce as a whole. So, I mean, keeping these scenarios to be common in everything, how does it all work if you're going to have the same divorce lawyer representing both of them as a couple?
Okay, Shruti, in the recent times, in this modern age and days, it's acrimony and mudslinging, and litigation is not going to take you anywhere. So the faster, and these are family relations. So the faster the couple resolves their differences, the better. They can both move on in their lives, and we always try. At least when an acrimonious relationship is before me, and the couple does come to me and say that we want to part ways, but we are not able to agree upon the see, maintenance is always an issue. One time settlement, the properties, during the matrimony you have purchased joint properties, then you have joint accounts, then you have membership in societies, and the children. Obviously the most important part is the children, like the custody of the child has to be with one, and access rights to the other and everything. So wherever the parties come together and say that, "Oh, these are what our problems are, and this is where but we have decided, underlying thing is that we have decided to go for a mutual consent divorce. This is known as a something called a mutual divorce by mutual consent. So every personal law has got actually a provision wherein the parties, without going to court unilaterally and making allegations on the other party, and seeking a divorce or some other matrimonial relief, both the parties can come together and present to the court something called a petition for mutual consent. Okay, both of them praying that their divorce be dissolved by a decree of divorce by mutual consent. So, like the term itself suggests, it is a mutual consent divorce. So you can have one lawyer, and that lawyer, it is a responsibility of lawyer actually not to be biased and to advise both of them equally and properly, and to the best of his ability, trying to protect the rights and obligations of both the parties. And then thereafter the settlement terms are drawn, and the first motion is filed before the court. Now, just because both of them have come to the court seeking a divorce, the court will not blindly grant a divorce. Okay, so there's a first motion. Now, in the first motion, statements of both the parties are recorded. Now, once the statement of the parties are recorded, the Hindu Marriage Act and most of the personal laws also provide that there is a cooling off period of 6 months which has to be adhered to. You see, so the next date which the court will give you is only after the period of 6 months. Okay, so after the 6 months, now what is this period for? The period is for second thought or rethinking of the decision to take a divorce, because in the Indian scenario, matrimony is basically holy sacrament. It is not just a contract, right? It is a relationship, because we have a family kind of a parampara, or you say the cultural aspect of India is actually still revolves around the family, and rightly so, perhaps, if I can say my own view. But the Indian law protects the family, the establishment of a family, right? So divorces are not given for the asking yet. So the courts have to actually give time to the parties. If the court feels that there is a probability that these two might come together and the marriage can be saved, the court will try its best. Again, even if it's a petition for mutual consent, you are still referred to the marriage counselor in the family court, and the counselor does try to ascertain that whether the marriage is actually a little broken down, or there are some probabilities wherein the parties can come together. Okay, so the first date is after 6 months. Now, after 6 months, both the parties have to again come to the court and reaffirm that yes, our initial decision, the statements which we had initially given at the time of filing of the petition, we are still interested in parting ways on the same terms and conditions. Okay, so it is at that time, after 6 months, that the court will ascertain that yes, the decision is correct, or the decision that both the parties are firm on their decision, and then the decree of divorce will be granted. Now, during that period of 6 months, if one of the parties has a rethink and says that fine, I don't want to give a, I did, this was a knee jerk reaction and I don't want to give divorce to this, to my partner. So she or he can actually withdraw the petition, withdraw the consent, and after 6 months, if she says no, I don't want to continue with my earlier decision, then the matter will lapse. That petition will lapse, and then whatever remedies are available to the parties, they can proceed with those remedies. So this mutual consent petition is very important. The lawyer can be obviously the same, because like the name suggests, it's a petition by mutual consent. So the parties are in consensus regarding the terms of parting, and therefore the lawyer can be the same. But a huge responsibility actually is on the lawyer's shoulders, and the moral responsibility and as well as the legal responsibility to advise both the parties is upon the lawyers. So this is as far as the mutual consent is concerned. I'll just pause here for a minute and just bring out, these days what has happened is, say for example, the parties are already in the court for say 5 years, 6 years. The legal procedure takes, it's quite delayed. So if the marriage is already, the issue of matrimony or their marriage or their any family matter is already in the court for a long time, and if you actually request the court, ki, we have already been fighting and we've already been staying apart for so many years and we really don't want to rethink, then you can request the court to give you a waiver of that 6 month period. And if the court deems it fit and proper, then the court will and may waive that period, and say after 1 month or 2 months, the court may permit you to file your second motion and get a decree of divorce at the earliest. So as not to prolong the agony, which is agony when a petition is in the court and that thing is already hanging fire in your mind and effectively not permitting you to move on in life. So then the court may grant you that waiver. But legally and statutorily, 6 month period is a waiting period, is a cooling off period, is a rethink period in which both the parties can reassess their decision, and come back or withdraw their consent.
Yeah, absolutely. I mean, again, quite insightful and a lot learned there itself. But as you were saying, I mean, time is the best healer, right? Whether 6 months is enough for a couple to decide, if they want to go ahead with the divorce or not. Like you said, the court tries their best to kind of keep the marriage going if that's possible. Okay, now, so that brings me to the next question that I want to ask you. We did talk about resisting spouses, and they can make the whole process of divorce very difficult by refusing to sign the necessary divorce papers, or by completely failing to respond to a request for divorce. Others, of course, try to others do so by trying, or I mean, hiding or trying to avoid service of the divorce paperwork. I mean, as dramatic as that sounds, but what if you're filed for divorce, completed the paperwork, and your spouse won't sign, right? I mean, what are the options? You did tell me what is the scenario in that case, but what are the options of the person, and will the judge still allow you to go on with the divorce? And what if one is not signing and the other one wants to go ahead, but how does it work? One person wants a divorce, one doesn't. Yeah.
So then it is something which is called a contested matter. So if at all I want a divorce and my husband won't give me a divorce, or he's not ready and willing to come for a mutual consent divorce, then the only option for you to file a unilateral petition for divorce on the number of grounds which have been mentioned in the enactment itself. So under the Hindu Marriage Act, which reasons are by and large fairly similar to in all other personal laws as well, except for the Muslim Marriage Act, the dissolution of you have the triple talaq this thing in the Muslim marriage, for as far as Muslims are concerned. But as far as the other laws are concerned, the grounds of divorce are by and large very same. So like you have cruelty, you can file a divorce petition against your husband or your wife on the ground that you have been treated with utmost physical and mental cruelty. Now, by physical cruelty, I don't mean that the husband has to be beating you every day. Cruelty can be mental as well. So, for example, we're just not getting along. Say for example, mental cruelty can be very relative. Like what is cruel to me may not be cruel to somebody else. If my husband says me one, you all saw that movie Thappad, one Thappad was enough for her to seek a divorce. But or somebody who is in a particular setting or particular social environment, one slap might not matter, as in might not be enough for the woman to actually go out and say that I want a divorce from my husband because he slapped me once. All right. So cruelty is something very relative to each person, but you can file a divorce. This is one of the grounds on which you can seek a divorce. Then you have desertion, you have adultery, you have like conversion. If the husband has or the other partner has converted from your religion to another religion, that becomes a ground for divorce. Then you have, say, like I said, you have a ground of desertion. So desertion means if my partner has left me for a period of continuous period of 2 years, immediately preceding the date on which I filed my petition, then that becomes a ground for divorce. Now, by desertion, I don't mean that it's not necessary that my husband beats me up every day, and today I pack my bag and leave his house. Then it's not that I have deserted him. It is something called constructive desertion, as it's not who has left whom, but why the person has left. So this is another ground of divorce. So there are actually as many as 13 grounds of divorces. So you can invoke any one of the grounds applicable to you and file a petition for divorce in the family court. Now, like I said earlier, once you file a petition individually making certain allegations against your partner, because you have to prove your case, and you cannot just generic your petition cannot be generic, as in every my husband is a drunkard, my husband comes home late every evening and he's in a drunken state. You can't say. You have to give specific instances of cruelty, like you have to actually narrate your ordeal. You have to give some very very specific, as in on this year in Diwali, something happened and we had an argument, and my parents-in-law asked for dowry, then my husband beat me up, or whatever it is. Those instances of cruelty have to be stated in the petition, and then notice will go to the other side. And like I said earlier, the family court judge will refer you for mediation. So once the husband or the wife, as the case it may be, appears on the notice, then both the parties are sent to the family counselor, and the process of mediation and counseling begins. And if at all, even during the counseling, if it appears that the marriage issues can be sorted and they can live together, then the petition can be kept on hold. And then say the counselor might say that 3 months, live together and come back after 3 months, and then we'll see. Or if the counselor feels that his marriage is not going to survive, so then she convinces the other side also that finish it off. It's more it makes more sense to move on in life instead of just hanging on to the other person. But ultimately it is for the parties to decide as to to be smart, or to move on, or to just have that vendetta to make allegations and just have that grudge and go on fighting in the court, which is not very useful for either the parties or the children. The most sufferers in the matrimonial discord is the children of the marriage, as nobody wins actually, both of them lose. But then the damage control, at what stage you want to control the damage to your relationship and to your life, is up to both the parties. So the court does help, the counselors help, but ultimately it's the choice of the parties. And then if the counseling doesn't work, then the matter is again sent back to the court, and then and any other suit, it is the matrimonial proceeding proceeds. And then later on, you have wasted so many years of your personal life in fighting in the court. Then the court will pronounce a judgment, allow it or dismiss your petition, whatever the court feels. I mean, as per the evidence adduced before the court. So that's the only way. If you are not able to come to a settlement, then you have to file a petition unilaterally and actually litigate. Over to you, Shruti.
No, I think, which is why they rightly say, think 1,000 times before you put the ring on it, because the procedures sound like, and obviously it's marriage, and easily getting a divorce is, I don't think that's possible or that's even justified at all. But like how you were actually mentioning that, it is what is relative or what is bad enough for a divorce depends on a lot of factors. One slap may be okay for somebody, one might just lead to a divorce, and there are so many other attributes of cruelty, which is, it is scary, definitely. And again, it depends from person to person. But I think end of the day, it is up to the both of them as a couple as to how they want to go ahead with it. So
In
that's,
fact, Shruti, if you just remember, I mean, if you just recall, just the last few days, this has been making news in the newspapers that what is marital rape? One court has, it's
yeah,
very sad, but one court has held that even if the husband has actually insisted on having establishing a sexual relationship with the wife without her consent and forcefully, will not amount to cruelty. Wherein another court has held that yes, this is also matrimonial violence, but that marital rape still doesn't exist in the statute books of India. So a specific concept as marital rape, although it is, any kind of assault is punishable under the Indian Penal Code. But these are the various complexities, which arise, which are thrown out of a matrimonial relationship. And it's best that if you feel the relationship is not going anywhere, it's best that you
yeah.
discuss things and you arrive at a settlement and you part ways. So that's the
Absolutely. No,
best
and
thing
I
you can
like
do.
I like the idea of 6 months also, because that also gives time to the couple to kind of understand if this is really a pertaining issue, whatever it may be, whether mental,
That's right.
physical, or whatever, and they actually want to part
Absolutely.
ways or not. So
Absolutely. Absolutely, Shruti.
that's that's great, Mrs. Gokhale. Okay, so moving on. Now I was going to say whether and where a marriage can be dissolved is a matter in the domain of the earthly law, obviously governing the spouses. We did speak about the various laws and acts of how divorce works within India, but the matrimonial laws are not common everywhere in the world and they differ from country to country, obviously. Now, the problem arises when the parties have their domicile in one country and one of them obtains matrimonial relief in a foreign country. So, could you take me through registering a foreign divorce in India and the terms and conditions around that?
Okay. So Shruti, this is a another complex issue, but you must understand the jurisdiction. So by and large, all the personal laws also go by a set set this thing as far as jurisdiction is concerned. So the law says basically that there are three courts which will have jurisdiction over your divorce or family matters. One is especially in case of divorce. One is where the parties got married. So if you have got married in Delhi, okay, then Delhi courts will have jurisdiction, or that is number one. Number two is where the couple has last resided together as husband and wife. Okay, so if say for example we got married at the place of the wife or the place of the husband, and the matrimonial home is in some other city or in some other state, then that state will also have jurisdiction to entertain and try your divorce matter. And the third is where the respondent resides. So if I am a wife and I am filing against my husband, and my husband resides say in Siliguri, then I can go and file in that Siliguri court also. And there is an additional jurisdiction given to a wife, okay, because this is a welfare legislation, and like I said, most of the matrimonial laws and the family laws are in, a woman centric, perhaps rightly so. But because what happens is, we get married and I'm living with my husband in another state, and if something happens and then I have to leave my husband's home and come back to my family in another state, then I can't be expected to actually go and file a divorce case where my husband is residing, right? So the extra ground given to a wife, extra jurisdiction given to a wife, is that wherever the wife resides, she is entitled to file a divorce petition in the jurisdiction of that court, wherever she is residing. So if I leave my husband in Pune and come back and live with my parents in Delhi, then I can file a divorce petition in Delhi. This is as far as the domestic, issues are concerned, as the jurisdiction is concerned. Now, in this day and age, you know that there are a lot of cases wherein the couple move to America, okay, or they get married over there itself in terms of the common law of that country. Then they can get a divorce over there also as per under their law. But if you have got married under the Hindu Marriage Act, then you have to dissolve your marriage also under the provisions of the Hindu Marriage Act, because your matrimonial relationship has been brought into effect, brought into existence under one enactment. So it has to be broken also, it has to be dissolved also under that very enactment. So that is something which is very important. Now, as far as so many times, I have a lot of cases wherein the couple is residing abroad, and the wife or the husband comes with the child to India, and then they just don't go back, and the other party is over there, and they file a divorce petition over here, and then it becomes very difficult for that person to come here and contest. But then if you have got married under the law over here, then you have to get a divorce under the law over here. But in custody matters, many times the wife or the husband may get an order in, say, New Jersey court. They get a they say that ordinarily the child resides in America, so the custody petition or whatever, the access rights or whatever maintenance, I'm going to file over there. Now that court also passes an order. All right, that court passes an order, and there is an order of custody over there, and the wife will comes over here and says, this is the order of the New Jersey court, and I want to whether a foreign judgment is binding in India. Answer is, by law, no. But there is a principle, something which has been evolved by the Supreme Court of our country, such as committee of courts. So if a court of another country has actually finally given a judgment in respect of an issue, then the courts of our country will by and large respect that judgment, unless it is completely contrary to the law over here. Okay, so this is something called a committee of courts. It is not compulsory, but recently I'll tell you one matter happened in Supreme Court, wherein the Supreme Court, you must be reading the papers also, it's coming, that the Supreme Court had already had actually adjudicated upon the custody issue of a couple. Now the father had acquired Kenyan nationality, and the woman was still is an Indian citizen, but the child, 11-year-old child, had also Kenyan citizenship. Now, in the Supreme Court had actually permitted, after mediation and all that, whatever the proceedings, the Supreme Court had already given the custody to the husband on the ground, on the condition that access rights will be available to the mother over here in India. So, say 4 months in a year, whenever the child had vacations over there, he was supposed to send the child over here. And the court had directed the husband to obtain a mirror order in the Kenyan court. Okay, so whatever the order of the Supreme Court was, the Kenyan court would also pass a mirror order in terms of the Supreme Court order of India, and the Kenyan courts will also say that yes, the husband would have custody, but the access rights, say for 4 months, would be with the mother. Now, what this father does, he says, yes, the Kenyan court has given this order. I have already made an application, and as soon as this order is passed, I'm going to get a mirror order over there. All those undertakings were taken, and thereafter the child was given to the husband. The husband then vanishes. He just doesn't comply with that order, and today the Supreme Court has had to issue notice to the Union of India to ask the Union of India as whether the husband can be traced through the High Commission or the embassy. All these are quite complex matters, and now even the Supreme Court is thinking of a process in which the child can be brought back to India, because the husband is Kenyan, the child is Kenyan. We don't have any jurisdiction over them. So the courts
Wow.
are also, this conundrum is quite difficult to crack. So it's
That's quite a
a
conundrum.
complex
Yeah.
situation. Yeah, absolutely. So, by and large, the jurisdiction aspect, if you've got married under the provisions of the Indian law in any personal law, you have to get a divorce over here. So that is actually, I can go on and on about cases which I have done, similar cases, but then it's a never-ending thing. So every matrimonial proceeding has to be dealt with the facts of that matter.
No, this Kenyan scenario is interesting actually. And viewers, I mean, what do you all think about this? This is just crazy. What do you have to say about this thing? I mean, I really hope the court comes up with something, because you never know, these kind of scenarios
Absolutely,
could crop up from any country. And then if it's going to be different in different
absolutely.
countries, then how does it all work? So,
Yeah,
wow, that's
it's very
interesting.
difficult actually. Mhm.
Yeah. So, Mrs. Gokhale, what I did want to ask you is, we haven't discussed the documents required towards fulfilling the divorce procedure, right? I mean, what are the immediate documents one needs to keep in mind when they want to go ahead with the
Yeah, so
divorce?
when if it's a unilateral petition or a consent petition, basically you need your marriage certificate or proof of marriage, because obviously you have to state that this marriage did happen, and of which you want a dissolution, right? So you have to have a marriage certificate, or perhaps a photograph of a marriage, or an invitation card, for the purpose of jurisdiction, that where your marriage took place, right? Then if you have children, if something is going to crop up out of the custodial matters, then say the birth certificate of the child, then and your residence proof. That's it. Because the grounds of divorce, if you're alleging cruelty, then the documents required, there won't be any documents. Inside the four walls of a bedroom, what documents are you going to have? So basically, it is a oral evidence which will, you'll have to enter the witness box and give your evidence, and then you'll have your cross examination and the witnesses coming and corroborating the parties and all that. So that if there are such, say for example, letters written by anybody, if the wife has written letters or emails to her parents or to her friends saying that every day my husband is troubling me, or they're asking me for dowry, or he's misbehaving with me, and whatever it is she has to say, then those can be used also in corroboration to her statements, saying that, see, last so many months or years I have already been communicating with my parents or my friends, and that can work as an evidence. So documentary evidence is as far as this much is concerned, but by and large you'll require your marriage proof and your residence proof, and say your photograph or something like that. That's it. You don't need documentation is not very complex in a divorce proceeding, Shruti. So that is
Okay.
it.
All right. So, with the growing rate of mutual divorce in India, courts have obviously tried to ease the procedure of mutual divorce by introducing the online filing of mutual consent divorce. So, this was done to cater to the growing number of mutual consent divorces that are happening by reducing the time and, free from mental trauma, of course. So, it definitely does make sense to me that courts can, stay. I mean, how can the courts stay behind when it comes to, digitalization of their work and making life hassle-free and less expensive as compared to, say, the traditional divorce methods that have been happening over the years. So, how does one file for a divorce in India online, and what are the requisites that need to be fulfilled while contesting online? Over to you, Mrs. Copley.
Okay. Shruti, basically online, there's nothing called as online applying for a divorce. Okay. So, but because of the COVID situation, when everybody started, online filing, all the courts, high courts and the Supreme Court, and even the lower courts for that matter, have started online filing of any matter. It's not just the divorce matters, but you can file a suit or you can file a plaint online. There are, the SOPs are given. So basically, you have to your petition has to be just to be uploaded and sent to the registry. But it is as good as filing a physical filing. You have to annex you draft your petition. It has to be signed by both the parties. Also, your lawyer, if you obviously if you're filing through a lawyer, and then your documents have to be uploaded. Then you get a number. But as far as a mutual consent or a divorce proceeding, unilateral divorce proceeding is concerned, you can't, unless it's a VC hearing, that is a virtual hearing. If the court is giving a virtual hearing, then you can log in on that particular day when you have a date, and then the court will ask you record your statements on a virtual hearing. But so that is for all the matters. So there's nothing specifically as an online divorce filing. So it's not as if you can just be wherever in the world and file an online divorce petition, unless it's just that online filing has been made available because of the COVID situation in the country due to the pandemic. And now the courts are again reverting to physical filing as well. So you can file your petition online on the website, on the link which has been given in the, it's there online only for various other courts. And you can just upload your petition as well as the documents required, and you'll get a date. On the date, if the VC hearing is happening, then you can just click onto the link which has been provided to you, and the court will record your statements. But as far as unilateral petition is concerned, Shruti, is still physical, because the examination and the cross examination generally doesn't happen in online. So the evidence cannot be recorded online as yet. So those petitions are on hold for the moment till the physical hearing starts. As far as mediation is concerned, in fact, that is happening in the Supreme Court of our country has done wonders. All the high courts in the states, and as well as the Supreme Court. I have myself have participated in a lot of mediation proceedings which have been referred to the mediation center in the Supreme Court and the High Court. And the mediation has worked out really fine. You'll get a link, and then both the parties have to join, and the counselor is there, and the counselor will talk to one party, then the other party, and whatever happens physically, the same thing will happen online. So there's nothing as a online filing as such otherwise. But in this situation, the pandemic situation, this has started, and I believe it will continue. the online, but it's similar to the physical thing. There's no great difference in both the filings, Shruti.
Okay, and this online filing is not happening across the globe as well, right?
No,
You're
in the
not
law,
just talking about India.
no, on I think abroad it does happen. Abroad, I'm sure various courts are going, and even in India it's happening, but it's not happening in all the courts. Like you see, we have these challenges of virtual hearings in the lower courts, especially. All the high courts and Supreme Court is doing everything online, but in the lower courts, that is where you file the family court is of all the districts don't have this not replete with the digital apparatus yet. So it depends where you're filing. For example, in Delhi, in the Patiala House Court, we can file online, but if you go to say
Okay.
Satara district, then I think you'll have to go. I don't think that online filing mechanism is available over there. So it depends from the court where you're filing. If the facility is available, you can do it online.
Okay, all right, Mrs. Gokhale. Moving on. After a divorce, it's always helpful to understand what the documents are and where you should go to get them. So, from what I understand, you get your divorce decree from court, but a divorce
Absolutely.
certificate, which is not issued by a court. So, could
So
you tell me what are these and what is the difference between these
yeah,
two?
yeah. There is nothing as divorce certificate. It's just the divorce decree of divorce. You get a certified copy from the divorce, and that is the proof of divorce. That's it. You don't have a separate divorce certificate, except perhaps in the Muslim law, when triple talaq has been given by the husband, then you need to go and register with the local imam, or I think they have the Darul Ilum, or their authorities, which give wherein the husband has to go and prove or show to that imam and the head the qazi, that he has given this triple talaq, and there are two witnesses which are necessary to corroborate that yes, this triple talaq has been given, and then the proof of divorce as a talaq nama is given to them. But the court decrees are, if you get a divorce through a court, then the court decree is the only thing which you will have as a proof of divorce. There's no such thing as a divorce certificate apart from the decree of divorce granted by the court.
Okay, Mrs. Gokhale. I also wanted to ask you about 498A. What is that and can it be filed post the divorce procedures? Could you take me through that?
So Shruti, this is 498 is a section which has been added to the Indian Penal Code by an amendment, because a lot of it, this was actually one of the fallouts of the famous case of Manjusha Sarda, if you remember, that abatement to suicide. She was given cyanide by her husband, and ultimately he was acquitted because there was no proof that it was he who abated her to taking the cyanide and committing suicide. Anyhow, that apart, so 498A has been inserted in the Indian Penal Code. It says that if at all a wife has died under in suspicious circumstances in the first 7 years of her marriage, then the presumption is that she was treated cruelly, and that thing has happened. That incident has happened because of cruelty by her in-laws, by the husband and the in-laws. So if a FIR is filed or registered by the police against the husband and the in-laws, then they are arrested, and the presumption is that the inquiry has to be done, investigation has to be done against them. So this is the by and large the general provision of the 498A. Now the Supreme Court has actually, because what happened was there was a lot of misuse. Whenever a wife wanted to get a divorce or move on, and somehow try to get more maintenance or whatever it is, then mechanically 498A cases were being filed, and harassment of in-laws and husband, and for every law which is enacted there is an abuse, right? So it doesn't mean that all the women were abusing that provision, but yes, there was an abuse. One cannot really go in a denial mode of that, but this is what is 498 is concerned. But right now the provision is this: whenever a wife goes to register a FIR against the husband and the in-laws in respect of this cruelty, for example, harassment for dowry, or any other violence or something like that, which is really serious, and it fulfills the ingredients of the section of 498A, then the police are actually refer the woman to something called a women's cell. that is a crime against women cell. It is known as a CAW cell. So every police station now has this cell. So the wife or the woman is referred to this cell. The husband notice there's a counselor over there. The counselor in a police station, right? So in that CAW cell. So the counselor will issue notice to the husband and the in-laws and all the family members, and the mediation and counseling takes place in the police station, and the police themselves through the CAW cell try to resolve the matter. Now, if the police feel, the investigation officer in that particular case feels that no, that whatever out of the inquiry or the counseling or the statements given by both the sides, that yes, an offence has been committed, then and then alone an FIR will be registered. So till then, the FIR, no FIR is registered, and a serious attempt is made to resolve these matrimonial issues. So this is in direct direction of the Supreme Court guidelines, and which has also been added in the CRPC, the procedure, how the police will investigate these complaints. So right now, once a complaint under 498A is made by a wife or a woman before a police station, she is sent to the CAW cell. The CAW cell, the counselor and the investigation officer will actually inquire into the matter, call the people who are required or who are proper parties to the proceeding or proper parties to that dispute, and should try to resolve the matter. Many divorces, I mean, many matters are settled over there, and then if there's a settlement agreement worked out in the police station, that same thing can act as a petition for mutual consent to be filed before the family court, and in that manner also a consent divorce can be obtained. So this is what is 498A and the procedure how this happens.
Okay, that was extremely insightful, and we definitely have learned a lot about the 498A. If you viewers agree, feel free to drop us a note in the comment section below. So, Mrs. Gokhale, I'm going to close our webinar with a question which obviously an expert like you would be better able to answer. In fact, we received this question while putting out content on our social media handles regarding our current episode. So the question is that while the court does give a cool-off period to every couple looking to end their marriage, considering mutually calling off a marriage is now easier and faster, when do you really think the couple should call it quits? I know it's an extremely generic question here, but from the couples you have come across, seen the patterns you yourself might have gauged, what's your take on this?
So like I earlier said also, Shruti, this is a very personal, this is a very, like you said yourself, in fact, this is a very personal thing regarding the decision to be taken by the husband or the wife. So if at any point of time you feel that this is not working, irrespective and despite all your efforts to, resolve the issues in your relationship, if it is not working out, I would advise that you call it quits and move on, because continuing in a relationship which is not working out is actually detrimental to the growth of both the parties and especially the children. Now, many times the wife or the woman feels that no, my children are small, I need to hang around more, I need to work towards resolving the issues in my matrimony more so that I can provide a better environment for my children. But I think I would advise this one thing to women thinking like this: continuing in the relationship, and telling yourself that I'm doing it for the kids, is going to harm the kids more than raising the children alone, by a single parent, or you or your husband or your, or the elders in the family. That will be much better for the kids than continuing with a damaged relationship, which is going to have a very, very disarming and a very detrimental effect on the children. So if at all you believe and you are working, both the parties, in fact, both the parties can seek counseling. If both the parties are willing, if they are actually able to think in this manner, and go for counseling, I would strongly recommend that please go for counseling. Try to resolve your matrimonial issues before a counselor. Third person can help you. But if at all trying and if you're not able to succeed, then it's pointless continuing a matrimonial tie only say because your children are young, or because the wife feels that I cannot, what will I do after going? Please try to be economically independent and try to settle and resolve your matter as fast as possible, because in the long run, it is nobody is going to win against the other. Even if you win a matrimonial proceeding, it's not a genuine win. It is just that both the parties have lost, but you need to control the damage in your lives and you can move on. It's just treated as an accident. It happens. You have to accept it. And please don't be worried about what is the society going to think. The society really doesn't care a hang as to what happens in your personal life. So just see and do what is good for you, what is good for your children, and make an informed choice and move on in life. You'll be happier. You can remain friends with your partner, and you can be happier and more efficient in your life than hanging on and clutching on to a relationship which is not working out. That's my advice, Shruti. And this is it's coming from personal experience dealing with so many matrimonial matters.
Absolutely. It cannot get more personal with the kind of experience, the kind of people you would have met and seen going through similar scenarios. And I think that was wonderfully put, Mrs. Gokhale. So with that, we are coming to the end of today's webinar. If you still have any questions about today's topic, request you to either drop them in the comment section below, reach out to Mrs. Gokhale on her email ID, which I am going to leave on the screen, or even her Twitter handle in case you guys miss seeing that on the screen. You will find it in the description box below, where you can head right after watching us today. Thank you once again, Mrs. Gokhale, for enlightening all of us on the grounds of divorce and the legalities of it. We absolutely look forward to gracing the platform on a different topic next week. And with that, this is me signing off. Please don't forget to like, share, and subscribe to our channel for personalized updates on our channel. Thank you all for your time.
Thank you, Shruti. It's been wonderful talking to you.